Thank you. You may step down.
Thank you.
Next.
Alexis.
What the media got off the top of my head.
Okay.
Bring them in. Let's bring the jury in. Ms. MacNeill, if you'll retake the witness stand.
Recognize what those are.
Bra. It's my mother's bra.
And did that belong to your mother?
That she worked with them.
Okay.
I
You
think it
recall-
was.
Thank you. Please be seated. We'll go on the record in the matter of State of Utah versus Martin MacNeill. He is present with his counsel. The state's attorneys are present. The jury is seated. Ms. MacNeill, Rachel MacNeill is on the stand. You may continue.
Okay, Rachel, I just have a few more questions for you. After 2007, after your mother's death, you lived with Alexis for a period of time?
That's correct.
Okay, when did you live with her?
I'm not sure of the exact date, but it was as soon as my little sisters were being,
Can you tell me, was it in the summer of 2007?
I believe it was July of 2007, but I'm not sure of the exact date.
Okay, you don't need an exact date. How
Okay.
long did you approximately live with her?
Until she was finished with medical school.
And when would that be, 2008?
No, she had 3 years left, so
Okay, so you lived with her for
2007, 2008, until
4 years? 3 or 4 years?
she had 3 years of schooling left.
So you lived with her for 3 years?
That's correct.
Okay. Great. Now, you stated that it was unusual for your dad to write you checks for large amounts of money.
That's correct. To give everybody $5,000.
Is that the check that your dad wrote for you? For the $5,000 that you're talking about?
I believe so.
And the date on that was March 31st of 2007?
That's what the date says here.
Okay, so you probably don't know when Easter was, but that's the date that he wrote that check out for you?
The date is, yes, on this check.
There's another check here that was written out to you. And that was written out to you by your mother. That's your mother's signature on a
For
check written
$1,000.
to you, right?
That's what this is,
Yeah.
this copy.
Yeah, isn't that a check?
This is a copy
That's
of a check.
I'm sorry, it's a copy of a check,
Yes,
and it's signed by your mother.
that's my mother's
Yeah, your mother's name is
name.
Michelle MacNeill.
Yes.
Okay,
So
and she's-
what's the question?
Is that her signature? Rachel, what I'm asking, is that a check from your mother written out to you for $1,000?
This is a copy of a check that's written in the amount of $1,000
To you?
to me, Rachel MacNeill.
Yes,
This-
and
yes.
so that.
I'm sorry, I don't understand the
So you got
question.
a check from your mother on April 1st of 2007, a day after you got the check for $5,000 from your dad, right?
I don't remember with this, but this is,
But that is,
if I went and got something for my mother or my father, I mean,
okay, you
I don't remember my mother giving me $1,000 to spend at all. There was a lot of time that I would go to the store to go shopping or do different things for a family, and I would get money to do so, but it wouldn't be mine to spend.
That's a check written April 26th of 2007 from your dad to you.
This is a copy of a check that my dad wrote to me.
$4,600.
Yes, I mean, this is a question.
And here's another check written out to you June 6th of 2007.
This is a copy of checks.
Okay.
Yes.
Written out to you.
Yes.
Okay. And is that your dad's signature on there? Or not?
You know what, with any of the signatures or the copies of these and things like that, I'm not 100% sure, but I do see that these are copies,
Okay, and there are copies of
And
checks
of checks.
written out to you.
but that's my name, yes.
Okay,
So
and
they
that-
are, yes.
That check amount is, what, about
This one?
$1,300?
$1,334.48.
And is that your signature?
This my signature? That's not my name.
I know, is that your signature, is what I'm asking.
Objection, relevance?
What?
Are you talking about the endorsement of the check? Which signature?
Here? This is my signature,
Okay.
right, the endorsement.
But on the front of the check, that's not your signature?
Objection, relevance?
I'm
It is
so,
overruled. Just point to the signature you want her to identify.
thank you.
The signature right here that's supposed, that written on a check from from Dr. Martin J. MacNeill and Michelle M. MacNeill.
Yes.
Is that your signature?
That's not my signature.
Okay, but that check was written out to you, correct?
That's my name. This is a copy of a check.
That's not your dad's signature, is it?
I do not know.
Okay.
He has very sloppy writing, so I'm not sure what these scribbles
Okay, Rachel,
are
do you
on this
recall,
copy.
writing an email to your sister Alexis on June 3rd of 2007? Do you want to look at this?
I
I'll
don't
just go by
recall
the-
a date of 2007
Okay.
I wrote an email. I'm sorry.
Is that your email address, Rachel Renee LDS?
That was, yes.
Okay, and the date is June 3rd of 2007?
Is that the question?
Yes.
06030.
Okay, so that's June 3rd, 2007?
That's what this says.
And then the subject of that email was called questions?
Objection, Your Honor. If she's seeking to refresh the witness's
So-
memory, she should read it herself.
Question?
I don't know that that's what she's doing. She hasn't testified that she doesn't remember. Is this an inconsistent
Know
statement?
what?
It is.
You may proceed.
Do you see the subject matter there?
The subject, it says on here, questions.
Okay, and that was written to your sister Alexis?
To Lexi.
Okay, Lexi?
Yep. So lexi@rockmail.com, that is her address.
Okay, and you said something is very wrong. Is that what you wrote to Lexi? Something is very wrong?
May I read the email?
Well, I'm
to
just going to
see
direct you
what-
through it.
Okay.
Okay.
I don't, I'm sorry, but I don't know.
Objection, foundation.
Overruled.
I don't
It's
know if you
June
can even
3rd,
bring this in.
2007 email. If you could go back to the podium and just read it to her.
Okay.
In that email, you said, Lexi, something is very wrong. I know you shouldn't bring it up with Dad, but something is very wrong with the nanny. I think we should hire a private investigator.
Yes.
Does this ring a bell?
Well, that's definitely a thought I've had.
Okay, I know Dad
Well,
is suffering
Definitely.
from Mom's death like we all are, but that doesn't mean that something weird isn't going on. Please tell me this lady's full name, Gypsy or Jillian or what? What is her last name? Where in Wyoming is her family? I know something isn't right and I want it to be taken care of.
Yeah.
And then you go on in that email to say, for the first time, why was Jillian at the temple that day? She didn't work in that area or live in that area. Why did Dad pretend not to know her name at the temple? And why did she just happen to be outside the temple that day? And so you were posing these questions to Lexi because you, on June 3rd, thought that something...
These are all questions I've had. I don't recall specifically writing that email on that day.
Okay, but from what you've said, that you did write this email on June 3rd of 2007? From what I just showed you, you identified this as your email.
That's my email address,
And this is your
and
email.
that's my sister's email address. I'm really sorry, but I don't know. I'm not an attorney, so I don't know if you can give me a false email. Those are all definitely questions I've
Okay, well,
had.
I'll
So I'm not, well, I mean, you can show me it, but
said that you thought that was false. Will you look at that?
no, I didn't say I think it was false. I'm not, if I don't read the whole thing, I'm just unaware if
Okay.
this is exactly what I've written. It may, if this is from
Okay, well,
2007.
go ahead. Do you want to look at that just for a minute? And
If I read the whole thing, is that all right? Or,
Sure.
okay, to say that then I've,
Just read it silently.
okay.
but have you identified this enough to know that
May
you
I-
wrote this email?
Okay, if I read the whole thing.
Sure.
Thank you. Those are all questions I've had.
Okay, and so Rachel, after reading through that, this is an email that you wrote. It's not some fake email.
Well, I don't remember writing that email specifically,
I understand.
but that seems like something that I mean,
This seems to
Sorry.
be from you. It doesn't seem to be something that was faked or something.
that doesn't seem like that to me. I'm sorry, I don't know what the law is, like what you're even
Okay, I'm just
able to
asking you,
bring.
does this look like this is your email? Because you brought up the question, you didn't know if this was faked or something, so I wanted to clear that up.
Well, when I read through the whole thing, when I was allowed to do that, because I don't know what you're handing me, and if I just read one line, then I don't understand.
Okay, but after reading the whole document, you think that you wrote that email, is all I'm saying.
Yes.
Okay, thank
Okay.
you.
No, I'm sorry if that was.
That's all right. Okay, and you've been diagnosed with a mental illness?
Have I been diagnosed in my life with a mental illness?
Yes.
I have.
Okay. And part of your mental illness is that you have delusions and psychosis, right?
No. Oh, wait. Part of my diagnosis? I'm sorry, I really don't understand your question right now.
You have had delusions and psychosis as
No.
in your life.
Okay.
It's just a question. Have you ever had delusions and psychosis?
No.
You've never reported to your doctor that you were having delusions and psychosis?
Foundation.
Sustained us to foundation.
You see a doctor named Dr. Jeffrey Hansen?
No.
You don't,
Jeffrey Hansen?
is that,
I don't know who that is. I don't recall.
okay, do you recall going
Do I see it?
to the emergency department in August of 2012?
I do recall.
Okay, at Intermountain Medical Center?
I'm not sure exactly.
Well, tell me where you went. If you recall going to the emergency department, where did you go in August of 2012?
My brother-in-law could tell you, but I was just driving with him. He drove and
And he
I
took,
walked in, so
he took you to the emergency department?
that's correct.
Okay, and he took you there because you were having delusions and psychosis, right?
No.
May I approach, Your Honor?
You may.
Now, who wrote this?
This is a medical report. Does that look like that is related to you? There's a name on there. Is that your name listed at the bottom?
That is my name.
Okay, Rachel MacNeill. And this is part of your medical records?
Action
I have
found
no idea.
has to testify about the record.
Overruled. She may be impeached using the document. If you can just come back to the podium, you may impeach her, and you have to accept what her answers are, so.
Okay.
My therapist can
Okay, so
explain
on
to you.
August 31st, 2012, you went to the emergency department like you said?
On what date? I'm sorry, I don't remember specifically the date.
August 31st, 2012.
I do not remember specifically the date.
But you remember August of 2012 going to the emergency department?
I know it was in 2012.
And you remember walking in there?
Yes,
Okay, and you talked to a doctor there?
I did that once, and I do not recall his name, but if you...
And you
if have-
reported, or he reported, that you were having delusions and psychosis, right?
If that's what he wrote, yes, I guess, if that's what that person wrote.
And you were reported as being very anxious,
Yes,
and you were very animated and had flight of ideas.
I don't understand the question.
Do you recall telling or discussing with the doctor your mental state?
I told him what had happened to me.
Okay. And do you remember telling him, or the doctor telling you, that you had altered reality testing? You can just say yes or no.
No,
Again, do you remember reporting twice that you had altered reality testing on that day?
again, the answer is no.
And you've been diagnosed bipolar?
Have I in my lifetime been diagnosed as bipolar? Yes.
I have nothing further, Your Honor.
You may redirect.
It's not.
Just briefly, Judge. Just clarify a few things, Rachel.
Okay.
When you testified earlier today about your father reenacting finding your mom in the tub,
Yes.
who was present there? Who was present with you when that reenactment took place?
Alexis.
Alexis, and your father and you were all there, correct?
That's correct.
When you returned home on April 11th, 2007, that
Yes.
afternoon when you found out your mom had passed, who do you recall being present at the home?
On April 11th, 2007, who was present at the home?
Sure, when you returned home.
Alexis was at the home. There were some neighbors, my father. Later, the rest of the children that day,
Are you aware of anyone else also noticing that the stuffed animals, decorative towels, and other things have been removed?
The question is, are you aware?
That's
It's
correct.
premature.
am I?
Do you know? State it that way.
Do you know whether or not other people are aware of the stuffed animals and the decorative towels and things being removed from the master bedroom upon the day of your mom's death?
Yes.
When the defendant gave you the $5,000 check, it appears March 31st is when that may have occurred. Who else was present when that happened?
I believe that, I can't remember if Damien was there or not. I know he received a check. I know all the adult children did besides Vanessa. But, so my mother was there, my father was there, Alexis, and myself. I can't remember specifically if Damien was there or not, though, at this point. I'm sorry.
Okay. When Gypsy moved into the home as the nanny,
Yes.
were other people present that day and then in the weeks following?
Yes.
Like, who else was there?
Everybody in the family. And then they went around
About your
together.
little sisters as well?
My little sisters, my brother Damien,
Elle,
Elle, yes, Giselle,
Giselle.
Damien, Eileen, different people. I mean, they've been present in the home. Alexis, myself. My father.
Nothing further, Your Honor.
Anything else?
No, Your Honor.
Thank you, Ms. McNeill. You may step down. Is she released from her subpoena?
Questions from the jury?
Oh, I'm sorry. I've released you too early. Have a seat here. The jury may have questions. Just pass them to the end of the row. Do you intend to keep her under trial subpoena? Any objection to her being released? Neil, let me ask you just a few more questions from the jury. The first is, did Mr. MacNeill describe turning your mother's body over during the demonstration? Do you remember that?
Sorry, can you repeat the question?
Yep. Did Mr. MacNeill describe to you turning your mother's body over when he was demonstrating that for you in the tub?
I don't remember.
Okay, thank you. The second question is, did Mr. MacNeill express any concerns to you regarding what he thought the autopsy might find?
I don't remember. I'm sorry.
Okay, thank you. Any follow-up questions? Good. Ladies and gentlemen, the parties have stipulated that the clothing that you've seen, that both the bra and the LDS garment top were cut. You may step down. Thank you very much.
Thank you.
Do you have a witness that we can deal with in 20 minutes?
We do, Your Honor.
Good, let's get that person called.
State calls Jackie College.
Call Jackie College. Ms. College, would you just come through here to the clerk's desk? Please raise your right hand and be sworn.
You do solemnly swear the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth so help you God.
Thank you. If you'll be seated here, please. Counsel, would you collect these materials? Thank you.
Good afternoon. Thank you for waiting. Will you state your name and spell it for the record, please?
Jacqueline College, JACQUELINECOLLEDGE.
What city do you live in?
I live in American Fork.
Okay. Did you know the MacNeill family?
I sure did.
How did you know them?
A long time, 20-plus years. I had a ballet school, actually, a satellite school of my business that at that time was in American Fork. And Michelle brought her children to train with me at the Petite Need Academy in ballet. So I knew them more as clients and in a business situation at first.
And did that relationship evolve over time?
Yes, it did.
How did it?
At first, just very polite, and eventually I could see the talents that Michelle had, especially to do with the fine arts. And so we started inviting her to help us and volunteer in different organizations for my nonprofit organization.
What were some of those talents?
Sewing, creating beautiful things, dinner. She was a wonderful cook. She was very good with people, I would say a very eloquent spokesperson for the arts generally in the community. So we used her in that capacity many times.
And what ballet organization was this?
This is Utah Regional Ballet.
Did you bring her into that organization?
Yes, we did. At first, she was our guild president, and she served on guild boards with many people. And then we brought her in as a board member for the board of directors for Utah Regional Ballet.
Okay, I wanted to back up and ask you some questions about, you said she brought her kids to your ballet. Which children were they?
Well, actually, I've trained all of them at one time or another, but these children, it was Vanessa and Alexis and Damien at the time that came to take ballet with me. And the older children participated in productions of the Nutcrackers. Whenever I needed extra dancers or performers, I eventually involved the complete family.
Okay. So it's, when we talk about, when you say you've eventually trained all of their children, are you talking about all 8?
Let's see.
Or are you talking about the first
Yes,
biological
I did
children?
even the chronological children in the beginning, and then when she adopted her children, they all trained with me as well.
Okay, when you said chronological, did you mean biological?
Biological, sorry,
okay.
yes.
As you brought her into the ballet organization, how did your relationship develop?
It was a good one. She was outspoken in our board meetings. She had wonderful ideas. She wasn't afraid at all to stand for something that she believed was a good direction for the company to go. She wasn't easily persuaded by other people. So I felt like she was genuinely there and contributing.
Okay, did you become friends?
Yes, we did.
Okay. How close would you describe that friendship?
Very close. She was a wonderful friend. She was often giving me advice. I could call her about things, but she wasn't the type of friend that I saw on a daily basis. I would see her if she was bringing the children to ballet, and I happened to have my schedule. We would see each other, but she was the type of friend that I knew was there if I needed her, and she came through very, very well.
Over the course of your 20-year friendship with her, or at least relationship, did you ever see signs of severe depression or anything like that?
And Michelle? No.
Objection, Your Honor, relevance.
I can speak to that, Your Honor, if you'd like us to approach.
Would
or-
you approach, please? The objection is sustained for the reasons stated at the bench conference. Go ahead.
Thank you. Did you become aware of Michelle's death?
Yes,
Did you attend her funeral?
yes, I did.
Did Mr. MacNeill speak at the funeral?
Yes, he did.
Will you describe his address?
I thought,
Objection, Your Honor. Speculation.
Overruled, she heard it. Go ahead.
And objection on foundation in relation to the form of the question. He's asking her to describe it rather than...
Sustained. Let's focus on specific statements. Go ahead.
Okay, will you, what did Martin talk about during his funeral address?
I felt like he talked, well, I know he talked more about himself than he did Michelle.
What did he say specifically about Michelle, to your memory?
I can't remember a lot, but I do remember him talking about how he would survive and the children would survive this terrible thing that had happened to them.
What did he say about himself?
I can't recall anything specifically, other than it just had a feeling of it was about him and his grief.
Okay. Did you interact with Martin and a young woman soon after the funeral?
Yes.
Would you describe that event?
My doorbell rang and Martin MacNeill and Jillian Willis, he introduced to me, and Sabrina, Elle, and Ada were at my front door. And
And this is at your,
this is at my residence.
and was that residence at the time also in American Fork?
Yes, it was.
And when in relation to Michelle's funeral was this?
It was immediately after. I felt that it was the very first Monday after, but in speaking with my husband, he reminded me that we had carpets cleaned and the house was at a disarray when they came. And we talked together about it because he was there at the same time and decided it was the following Monday,
So.
the week following.
You thought it was the Monday after the funeral, but it possibly was the week.
Yes.
A week later.
But it was very close to the funeral.
Okay. Did you have a conversation with Martin at that time?
I did.
What did you talk about?
First of all, he introduced to me Jillian and said that she was going to be the new nanny for the children. The first thing I said to him is how sorry I was because I really didn't feel like I'd had an opportunity to speak to him. And I said, I just can't believe that Michelle is gone and that she had health issues. And he told me that she had had health problems her whole life and refused to take medication.
Okay. Did you offer any help to the MacNeill family?
Yes, I did. Their three youngest children were still training at my school. Actually, yes, Ada was still there too at that time.
Can I
And-
stop and clarify real quick?
At the ballet school,
Is this during the same conversation or is this
Yes.
at a different time? Okay.
yes.
Go ahead.
And at a different time. I just told him that I'd be willing to help in any way, getting the children to ballet because they were very involved, and any other way that I could help. I was just trying to be of service of some.
On the offer to get his children to ballet, was that, did he take you up on that offer?
Not right there at that time. He said that he would be in contact with me, and then later I got a phone call asking if I would help.
Okay. Did he explain why he wanted your help?
Yes, he told me that he'd hired a nanny and that she was a nursing student and she would be available to pick up the kids from school and get them to ballet. And because I'd already offered, and my daughter as well, he said that it would be great if we could pick them up and get them there because the nanny wasn't able to do it.
Okay. Do you recall Mother's Day of 2007?
Yes, I do.
Did you attend a church service that day?
I did.
Objection, Your Honor. Relevancy.
Approach, if you would.
So, Mrs. College, you were saying that you attended a church service on Mother's Day.
Yes, my grandson was christened that day and received a blessing in my daughter's ward, which happened to be the same ward as the MacNeills.
Okay. Did Martin MacNeill address the congregation that day?
Yes, he did.
And this is on Mother's Day, correct?
Yes,
Did he speak about his recently deceased wife?
yes.
And what did he say?
He spoke about how sad he was about that to begin his talk. And then most of the talk was about single mothers and how important it was for single mothers to be recognized on Mother's Day because of all the work that they do, even though they may not be married.
Did you ever come to know Gypsy Willis?
I met her. She was in attendance that day at the meeting. That's as much as I know about her as
Do you
when
know
he
whether-
introduced me.
Do you know whether she had children?
I don't. I believe I heard that she has had a child, and I couldn't tell you
Objection, Your Honor.
who told me.
Sustained as to hearsay.
I have no other questions.
Do you have cross for this witness?
You testified that at some point after the funeral, Martin and Gypsy and Elle and Sabrina, I believe, came to your house,
And Ada,
and Ada as well. And at that visit, Gypsy was introduced to you as the nanny.
yes, she was.
And so when they came to your house, it was your understanding that she had already been hired as the nanny, correct?
Yes.
Fair to say that that could have been 3 weeks after the funeral?
It seemed so close to the funeral. I wouldn't dare say that because it felt like everything was happening so quickly. The death, the funeral, so to me, it seemed sooner than 3 weeks.
Could have been 3 weeks, though. You're not sure?
That's not what I think. I'm
Okay.
sorry.
All right, that's all the questions I have.
No redirect.
Thank you, Mr. Perkins. Any questions for this witness? Doesn't look like it. Is she released from her trial subpoena?
Yes.
You're released from your subpoena. You may step down. Thank you. Ladies and gentlemen, we'll be in recess for today. Thank you for your attention. I'd like you to come to court tomorrow morning at 9 o'clock, if you would, rather than 8:30. I have some issues to deal with in the morning. I'm hopeful that we'll get started right at 9 o'clock. Remember my admonition to you, don't form or express any opinion about the case. Don't have any discussions amongst yourselves or with anyone else about any subject matter of the trial. Do no research on your own using your computer or something else. And finally, avoid television, internet, radio news coverage of the trial. Have a pleasant evening. Thank you. Please be seated. Counsel, we had a bench conference regarding a stipulation. Would you like to state that for the record?
Yes, Your Honor, the defense would stipulate that we are not advancing any sort of a defense that Michelle MacNeill committed suicide.
And does the state accept that stipulation?
It does, Your Honor, with the addition that both parties have agreed that the jury would be instructed as in that way.
That I will give an instruction regarding that stipulation of fact. And will the state prepare that?
Sure.
Thank you. Do you wish to be heard on foundation for the child's testimony? I think this is your motion. I've heard a lot of argument so far, but we now have a factual record that we can speak to.
Your Honor directed us to a number of cases that you felt were relevant to this issue. We obviously have cited additional material in our pleadings, which I know Your Honor has reviewed and considered. In the cases that Your Honor directed us to, there's State v. Fulton and State v. Burke, which have similar holdings, and their holding is that a court may exclude the testimony of any witness if the probative value of that witness is substantially outweighed by the potential prejudicial effect. And in both of those cases, the court was referring to, the appellate courts of Utah was referring to child witnesses who may have been tainted. And in the holdings of those cases, the court indicated that one factor that must be considered is whether the child had either been intentionally influenced or even unconsciously influenced by a party, or I'm sorry, not by a party, by a person. And I believe that the language in Fulton and Burke that unconscious influence is a factor that must be considered is particularly relevant here. Obviously, from the defense point of view, we believe that there has been more intentional influencing of the children, and that has led to Ada's memory remarkably improving 4 years after the events allegedly occurred, which is something that just generally is unheard of for a child witness. But even if the actions weren't intentional, the unconscious influence of Alexis being directed by the investigators to have repeated contacts with Ada, based upon the information that we heard this morning and as we've put in the pleadings, must be deemed to be true.
The Fulton court says intentionally or unconsciously influenced, such that the child is simply parroting what others have told her to say. Can you give me some examples?
Yeah, one obvious example.
The jogging suit, I think, is
Jogging suit, yeah.
one.
And so we have the conversation that supposedly occurred on September 2nd of 2007 between Rachel and Ada. And in that conversation, Rachel reports that Ada found her mother and that she was wearing black and blue pants and shirt. And Rachel parenthetically puts in that email that she thinks that it was her running suit. And in all subsequent recitations, I believe, Ada reports that Michelle was wearing a running suit.
Yeah.
I think that is clear evidence that Ada is susceptible to being tainted. I don't know exactly how that taint occurred. I don't know if Rachel or Alexis told Ada that Mom was wearing the running suit. I don't know if Ada overheard that conversation. But what I do know is that Ada has been influenced to the point that she believes that it's true. And it makes it impossible for the defense to cross-examine a child witness based upon memories that have been either intentionally or unconsciously created through the influence of people that were very important to her.
Are there any other specific statements that you feel like illustrate that degree of influence?
I do. I think that the statements that occurred after the January 5th, 2011 interview are virtually all the product of either intentional or unconscious suggestion by the biased interviewer, which was Alexis.
Is that the the January 5th, 2011 interview, is that between the two investigators, Alexis and
And Linda Clough,
Linda Clough?
yes.
Thank you.
And we went over that this morning.
Yeah.
In that interview, Alexis very firmly and clearly expresses her understanding. Today, Alexis said that, well, she just worked a 30-hour shift, and so she was wrong. Your Honor, that's not a credible explanation based upon the way that that interview occurred. And Alexis adamantly refuting Investigator Whitney's statements about how he believes things occurred and what the Daniels said. Alexis went to the point of reminding Mr. Whitney that the Danielses arrived after Ada had already perceived what Alexis had been told. And as Exhibit J, I believe it was, reflects, the transcripts, there was no ambiguity in what Alexis said. It wasn't like it was just a mistake. And she reported that what she was relaying in that interview was what Ada had told her. Jeff Robinson in that interview agreed with Alexis. Doug Whitney disagreed and explained his reasons why. Both Jeff Robinson and Doug Whitney had testified that they had shared investigative theories with Alexis throughout the case. And then, shortly after that interview, all of a sudden, Ada's testimony changes. Jeff Robinson sends her an email, sends Alexis an email, asking Alexis to speak with Ada and interview her. Ada testified at the preliminary hearing that she understood that Alexis believed that her father had killed Michelle. There's no question that Ada had been exposed to Alexis's beliefs. So we have this interviewer that believes that Martin had killed Michelle, interviewing the child witness now in 2011, we're almost 4 years after the incident occurred. Just 2 weeks earlier, Alexis had very firmly expressed her opinion about the number of times, her opinion as a result of the number of times Ada had just talked about the incident. And so now, almost 4 years later, after hearing more of Investigator Whitney's statements, Ada's testimony changes completely. The drawing that was created, it wasn't even Ada's drawing in large part. Alexis testified that she's the one that drew the bathtub. She's the one that put the words down on the paper. This wasn't a product of Ada's. It was a product of Alexis's, who believes that Martin killed her mother, interviewing this child witness. Investigator Robinson then sends 2 or 3 additional emails asking for clarifications. One of them leads to a report back from Alexis that the tub was only a quarter full. One leads to new information saying that Michelle's eyes were open.
Is that you, I think? That's the email that has significant detail in it.
Yes, I think there might have been one earlier that had that too.
Okay.
And then you ended up having, in addition to the eyes being open, that Michelle's chest moved in and out once or twice, which was consistent with the prosecution's theory at the time that Martin had sent Ada away. She was gone for a while, and had after they discovered Michelle, and that Martin had killed her then.
Objection. Facts not in the record to support that.
Well, it's argument. I'll allow you to respond.
And so here we have 4 years later, lots of new facts being introduced. The McDonald's fact is another interesting change. In the CJC interview, Ada testified that when she was over at the Daniels' house, that they were talking about going to McDonald's. Now, in 2011, the story is that Michelle was going to take her to McDonald's. In the CJC interview, Ada said that her mother was too sick to drive on April 11th. Now the story is that Michelle was planning to drive Ada to McDonald's that day. Your Honor, it's very difficult to say without having any witness to Alexis's interviews of Ada exactly what she did, either overtly or implicitly, to affect Ada's statements and to taint her memory. But the examples that we've discussed, I believe, are clear examples that Ada's memory has been tainted. And I don't believe that a remedy can be fashioned to allow Ada to testify about some things that we don't have really good evidence of taint that were first disclosed after the interview on January 5th of 2011, but not allow her to testify regarding things that it's pretty clear was the product of taint. Because it's impossible to get a full record of exactly what Alexis did intentionally or unconsciously. Alexis testified at the preliminary hearing that she had not spoke with Ada prior to the CJC interview. The defense's position is that we think, in light of the taint of Ada, that she should be entirely excluded from testifying. Alternatively, if Your Honor is not comfortable doing that, at least after the CJC interview, any additional memories that were created or reported should not be allowed. The taint is further evidenced in the February 26, 2009 email from Alexis to Mr. Whitney. In that email, Alexis reports that she has spoke to Ada multiple times, and Ada keeps telling the same story. 2 years later, it changes.
Can you think of ways what that might look like when you talk about just using the CJC interview? I mean, it's going to be very difficult to have a child be instructed before coming to testify about what memories were post September 8th, 09 and what were later. I think that
Impossible.
it's impossible. And so, I mean, would you just contemplate the playing of the Children's Justice Center interview?
Either that or having somebody read it back and forth. Either one of those, I think, would be a possibility.
You know, that this Children's Justice Center interview, you do have testimony that Alexis did not speak to the child before that interview.
That's what she said, yes.
And that's, so, you know, in terms of reliability, that's probably the cleanest thing we have.
We know Rachel spoke to the child before then.
We do, yeah. Okay. And the other thing I've thought about is, in the analysis, you would agree that the mere fact that children, as a general rule, are more susceptible to suggestion than adults. The mere fact that that may be true doesn't disqualify the child. You have to look to, otherwise we end up with a status rule about competency again.
I agree with that just because children are susceptible does not render them incompetent. And I believe that the analysis that is anticipated in Fulton and Burke, and which we are bringing up here, is when there is evidence that a child who is susceptible has in fact been tainted.
Yeah.
And this is a case where I believe that that based upon the record that we've presented, we can show that she's been tainted. And not only can we show that she's been tainted, we can show that she's been tainted, at least in part, as a result of specific requests from the Utah County Attorney's Office investigators.
The Michaels case that you cited talks about a burden-shifting analysis where the defense needs to come forward and show evidence of improper influence or at least unconscious or intentional influence, and then the burden shifts to the state to show by clear and convincing evidence that the statements of the child are reliable. There's nothing in Utah that supports that, and do you think that's a good analysis?
I think it's instructive. I recognize that it's not Utah law.
I guess it goes to, can your evidence be rebutted? Could the state come back and say, no, by clear and convincing evidence, her statements at the CJC interview and the preliminary hearing are generally consistent. Is that enough to rebut the initial evidence of taint?
I don't believe that the Michaels case anticipates a rebuttal on a piecemeal basis, statement by statement. I believe it's addressing the issue of taint. And there are significant differences between the CJC interview and the preliminary hearing testimony. There are a number of aspects in the preliminary hearing testimony that are consistent with the March 30, 2011 email that are, I believe, clearly the product of taint. And so in responding to Your Honor's question, I think that the Michaels case is instructive, and if Your Honor were to follow that, the rebuttal is not on individual aspects of testimony, but it's on taint, whether intentional or unconscious. In this case, I submit that there can be no rebuttal of that because of the facts that are admitted. There's no dispute that the investigators asked a person who is acting as a mother figure towards the child, who also believes that Martin killed Michelle, to then go interview the child over and over and over again.
So in your view, because this goes to memory itself, then it really is an all or nothing proposition.
Well,
the witness either testifies or doesn't testify.
I believe, as we've set forth in our motion, that she should not be allowed to testify. I recognize that Your Honor has broad discretion, and so in addressing that, I could see a potential slicing up of the pie, so to speak, in relation to evaluating potential taint from up to the time of the CJC interview, and then evaluating it afterwards. The only evidence that we have of potential taint up to the CJC interview is the known statement that Rachel had spoke to her, and we can see that Ada was tainted to a little bit by adopting that. But then after that, particularly after the January 5th, 2011 interview and the repeated requests from the investigators to have Alexis interview Ada, and the ongoing process of reports, things just blow up in relation to Ada's report, and her memory gets better and better and better. And that's just not the way the experts say it happens. Notably, the state hasn't even attempted to rebut our expert testimony, and I think that that's because the principles that Dr. Gregory sets forth in her opinion are generally accepted by experts in this field. And so if Your Honor isn't inclined to exclude her altogether, we think that statements that are made after the CJC interview ought not to come in, because they're not only just the product of taint, they're the product of state-created taint, which I believe violates the fundamental fairness requirement of somebody who's on trial for their life, to receive a fair trial.
Okay. Thank you very much. Mr. Grunander.
Fair amount to respond to. First off, I'd just like to address the issue with the investigators. As prosecutors, we concede and we acknowledge that as far as best practices, certainly it isn't to send an untrained individual to go interview a child. But the fact that that occurred does not show the taint, does not prove the taint. Number one, the investigators here, they have not talked to Ada. They have not interviewed Ada. So really the issue we're dealing with here is the conversations between Ada and Alexis, and then Ada and Rachel here.
And Ada and Patty Johnston.
Ada and
right?
Patty Johnston, that's correct. So I think that, quite frankly, is a red herring. And no one has a constitutional right, no defendant has a constitutional right to require a victim or a witness who's a child to only be interviewed by a trained professional. We need to give some context to this. Every day in America, victims of sex abuse, children testify in the courts throughout the country. And oftentimes, in those scenarios, there are hotly contested custody disputes going on between the parents. So the allegation or the possibility of taint certainly
Mm-hmm.
exists. I think the most persuasive cases, the most on-point cases here are the Burke and the Fulton case. And I think the Fulton case, it's important that to give context to the factors, because there are factors that the court suggests the court should consider in determining under 403 the admissibility of child testimony. And the court has already honed in on the most, I think, relevant one in this matter is looking at whether the child's been intentionally prepared or unconsciously influenced by adults, to the point that the child is only parroting what others have said about the relevant facts. That's really what we're looking, is parroting the facts from someone else. But the legal support here to support these factors, there's a Hilaris v. Jankowski case out of Illinois, a 1942 case, where to support this idea that he was simply parroting, it was the boy injured when he was 4 years old, testified 4 years later, and admitted that he was repeating what he had heard others say about the accident. So there was an outright acknowledgement by the victim there, the boy that was injured, that he was repeating what others had told him. State v. Nelson, a 1986 case, is also referred to. Reliability of child statements depends in part on number of times statement was repeated or rehearsed. We have testimony from Alexis, who talked with Ada a number of times about this. She described as best she could how she would approach the situation. She tried to be very cautious about it. She testified that she was mistaken in her belief about what Ada had reported with respect to the position of the body during that one interview. That's what we have here. So I understand the suspicion, I understand the concern here, but I believe it amounts to speculation, Your Honor, to say that she has been tainted here. Everything that was discussed this morning, as far as the emails with Jeff Robinson and with Mr. Whitney, and also with Alexis, and the interviews and so forth, that can all be explored on cross-examination of these witnesses, and also with the child witness herself. There is certainly nothing to stop the defense from saying, now you say that the body position was this, but didn't you tell Alexis at some point that it was reversed? So that can certainly be explored on cross-examination. Rule 403, and I referred to this in the pleadings, but when it comes to excluding relevant evidence under 403, it's an extraordinary remedy to be used sparingly.
It's Fulton, is that right?
It's a Woods v. Zelef case. And in that decision, there's some language, prejudice which calls for exclusion is given a more specialized meaning, an undue tendency to suggest decision on an improper basis, such as bias, sympathy, hatred, contempt, retribution, or horror. Those are very strong terms. And I think that the idea that the jury listening to Ada MacNeill describe how she first saw her mom, the first person to see her mom dead in the bathtub, that her description of how she was found would lead to the jury making findings, conclusions, a decision in this case on an improper basis, such as bias, sympathy, hatred, contempt, horror, retribution, I think is certainly a stretch.
As I've thought about this, the eyewitness identification analysis seems to be another one that may be a good fit, in that it's generally recognized in the science that eyewitness identification can often be wrong and influenced by so many factors, and in that context, the court makes a threshold finding of constitutional reliability. But the mere fact that it's questionably reliable doesn't keep it out of court. It does, so long as it meets that threshold standard, evidence that is questionably reliable comes in, and we can have memory experts, and that's how we challenge that. It seems to me that it's that constitutional threshold that we're talking about that doesn't exclude all evidence that's questionably reliable, but there may be some that is so, there may be an eyewitness identification that is so tainted that the Constitution requires that it be excluded.
And I would agree with that, Your Honor. And if inconsistencies and suspicion of taint, those kinds of things do not defeat testimony. I mean, if there's inconsistencies here, those can certainly be explored on cross-examination, certainly explored through a number of other witnesses. Take, for example, the neighbors in this case.
Yeah.
I don't think anyone here believes Christy Daniels and Doug Daniels, husband and wife, are lying about the clothing that Michelle was wearing. But even a husband and wife who were there the very same day and moment described the clothing that she was wearing as different. That doesn't defeat their testimony. This can certainly be adequately explored on cross-examination and through other witnesses, as I think was demonstrated in the hearing this morning. It can be talked about. The CJC interview, Your Honor, just to give some context to that interview, you know, oftentimes our CJC interviews are dealing with victims, and the interview has a certain set of elements that he or she is asking the child about. So there's kind of a script as to what's going to be asked. So they're relatively exhaustive from the point of view of a prosecution or the investigation can rely on that interview and oftentimes doesn't need another interview because it's exhausted and you get the child's statement. Here, this was very early on in the investigation. And as Mr. Whitney testified this morning, it was all over the place. He was being pulled this direction and that direction. Certainly one of the directions was to interview the child that first found Michelle in the tub. So an interview was done. But no one had an idea of even really what questions to answer, or excuse me, what questions to ask, what was relevant at the time as the case proceeded. That's the reason why additional questions were asked, and I think certainly under a best case scenario, I think a list of those questions probably would have been compiled, and a subsequent CJC interview would have taken place and should have taken place.
It's curious to me why she was interviewed in the proper context and in the proper way once, and then didn't happen again.
Sure, and we concede that, but I think that Your Honor's opinion on that, my opinion on that, others' opinions on that, is not enough to defeat admissibility of Ada MacNeill's testimony. This is hugely relevant for us because she is the first one to find her mother.
How, the other context I've thought about is where a statement of a third party admitting criminal conduct, statement against interest, admitting criminal conduct, a defendant can't use that unless it's corroborated in some way. And it raises this kind of issue about reliability. It's another instance in where the courts say, yeah, we know that that is unreliable inherently, and so we treat it differently. You've got to have something, and I'm wondering how much corroboration ought to factor in to the analysis, because when you look at what Ada has said in the CJC interview and at preliminary hearing, much of it seems corroborated by what the Daniels see and the Zagualera.
I think you're correct, Your Honor. There are certain circumstances under the law. For example, you know, if someone walks into the police station and confesses to a crime, that's not enough for the state to prosecute them. It has to be corroborated. There is a lot of corroboration here, Your Honor. I would like to make a brief record of that. With respect to Christy Daniels, the neighbor, she has corroborated, or it would be consistent with Ada's testimony, the time of day of the event, just after Ada having returned from school, the fact that Ada came over asking for help, the body position that Ada would describe versus that of Christy Daniels, with her lying on her back side area, her face up. The direction of the body would be corroborated. The fact that she was fully inside the tub. Doug Daniels can do the same as far as the time of day, the body position. Michelle's head was found underneath the faucet area end of the tub. Angie Aguilar, the other neighbor, can talk about the time of day, the fact that Ada came over asking for help. Again, the body position, the body was fully in the tub. Even the defendant's own statements to the 911 dispatcher corroborates some of Ada's testimony as far as the time of day, the fact that Michelle was found in the bathtub, that she was found unconscious. The court has also heard from Steve Mickelson, the colleague of the defendant. The court's also heard from Eileen Hang. And the defendant made statements to both of these individuals that covered the time of day, the fact that he had picked up Ada from school and they'd returned home from school, that Ada was the first one to find her mother in the tub, that she came out telling him something was wrong, that she needed his help, and so he went into the bathroom. And then we had testimony today from Rachel MacNeill that the defendant told her that Ada had first found her mother and that she was ruined, and that he had repeated that. So there are a number of facts that are corroborated to suggest the reliability of her, and to the extent that she has been inconsistent, and I would say she hasn't. The only reason we think she may have been inconsistent is based upon Alexis's report in that interview about the body being in the reverse position. The CJC interview contains very little information early on in the investigation, and it was added on. I would also say prosecutors around the country reserve filing charges involving child victims at times to allow them to mature, to be able to speak and to describe. I'm not saying that someone's memory gets better over time, but their ability to communicate what they saw can improve over time with maturity.
On the corroboration issue, I think there has to be a limit to that, because the fact that Ada's testimony at preliminary hearing falls in line with other testimony is the problem, and so or at least from the defense's side, that is the problem. And so you'd almost have to look at the idea of looking at corroboration of the less tainted scenario, and which is the CJC interview. Do you see what I'm saying? I mean,
Yeah,
corroboration has to.
I see the concern, especially from the defense perspective, but I don't think it's totally a valid concern. Reason being, I don't think anyone here believes that the other witnesses that provide that corroboration, that their testimony has been tainted or influenced or changed. So if we are to believe that their testimony is reliable and Ada's is consistent with that in large degree, that to me shows that Ada was present and that she viewed the event similar to the way other people viewed it. The reverse body position, I think it could easily be mistaken. I think, and this is just argument, but we have a defendant who, we've heard testimony, he had a bad toe or wasn't physically capable of getting his wife out of the tub or something to that effect. It would simply seem odd to me that if she was found in the reverse position, away from the faucet, he drains the tub, and for whatever reason he would then switch the body around over by the side of the faucet, and where it gets even deeper because of the drain here, which would make it more difficult to pull the person out. So I think that was mistaken. I think that the way Ada has testified at the preliminary hearing and given other statements to other people about how her mother was found, as opposed to how Alexis reported it in that interview, is correct. I think that that's just more of a commonsensical approach there.
Thank you very much. I appreciate your careful thinking on this. Anything else?
The reverse body position illustrates the problem. In the January 5th, 2011 interview, Alexis was absolutely confident in what Ada had reported. Doug Whitney disagreed with that. Subsequently, Ada's testimony is different after repeated requests from the investigators to Alexis to interview Ada. And so the point is not exactly on how Michelle's body really was. The point is about what Ada's testimony was. And the taint arises because the investigators asked a person who was very determined to pursue this case, as she testified on the stand today, to go and interview a critical witness over and over again, leading to that witness's testimony to conform to other witnesses' testimony. That's the problem.
Yeah, and that's where I say corroboration can be evidence of taint. It can both bolster reliability depending on at what point you draw that line. Yeah.
And, Your Honor, the prosecution started their argument by saying that every day child witnesses are out there and are part of reporting crimes, and they're being interviewed. Heaven forbid that every day we have police officers going out and asking people who accuse another of crime to go and interview child witnesses over and over again. What occurred in this case cannot be tolerated in our system of justice. It's fundamentally unfair. It deprives my client, Mr. MacNeill, of his right to a fair trial if Your Honor were to sanction the Utah County Attorney's Office's investigators' conduct in this case. We know from the evidence that we had that there was taint. holding the defense to a high burden of trying to prove all of the taint based upon unrecorded interviews that Alexis conducted is unreasonable. We can show taint. Alexis is not only a biased interviewer, as we submitted in, I think it was the April 26th interview, she's an interviewer that the investigators themselves are questioning her own credibility. They indicate the more questions they, or I shouldn't say they, Investigator Robinson indicates to Investigator Whitney that the more questions they ask Alexis, the more conflicting answers they get.
Was that Alexis or Ada? I can't remember.
Alexis.
Was that Alexis?
Yeah. And so this unreliable interviewer, now granted that email occurred after
Yeah,
the request
it's
for,
at the end.
yeah, but it doesn't change the fact that the opinion was expressed. And so to have somebody that is deemed to have some questions regarding reliability also be the biased interviewer adds more basis to our arguments for excluding this information. It's not an issue of credibility that can be remedied through cross-examination. Credibility issues, granted, can oftentimes be dealt with effectively in cross-examination. This isn't such a case. It's a reliability issue. It's an issue where memories have been influenced. That's a whole different scenario than the line of cases that deals with the great effect of cross-examination in ferreting out the truth.
I'm not parsing hairs with you here, but I'm having a hard time drawing the distinction between credibility and reliability, because cross-examination frequently focuses on whether the jurors should deem a person reliable. I mean, that's when we test memory and perception, consistency over time. Those are all directed to whether a person's, the testimonial faculties of a person are such that they can render reliable testimony. So I'm having a hard time really drawing that distinction. Credibility seems to me maybe narrower, but we test reliability through cross-examination every day.
To a degree, yeah, I understand Your Honor's point, and it's well taken. But reliability in the sense of a particular witness is different than credibility, whereas credibility may be focusing on whether a witness is telling the truth.
Yeah.
Reliability is focused on whether the witness's memory that they believe they are truthfully portraying was a real memory. And in this case, it's our belief that those memories were created in the witness, the child witness, as a result of a taint-filled process that cannot be adequately remedied simply by saying, well, cross-examination is allowed.
Okay.
Your Honor, if Ada's testimony, at least after the January 5th, 2011 interview, were not excluded, I have a hard time imagining a circumstance where a child witness's testimony who has been tainted would ever be excluded. We know she was tainted. We know that it was tainted as a result of state-requested conduct in this case. That seems to be the exact type of extraordinary case that requires an extraordinary remedy in order to ensure the fundamental fairness of the justice system in the United States. The prosecution argues that the evidence is hugely relevant. It's also hugely relevant to the defense. to have evidence be reliable and fairly obtained and presented. As Your Honor pointed out, the prosecution's arguments about corroboration is a circular one. To say that there are various other witnesses that corroborate the child witness's testimony illustrates the problem, is that the child witness is tainted to be consistent with the corroborative witnesses. What they're
Yeah, and that's why I say at some point a line has to be drawn where you're saying, what was the child's testimony pre-improper influence? And if that testimony is corroborated in some way, then that does weigh in favor of its reliability. But I don't think you can look at post-improper influence and say there's corroboration, because that is the problem. Am I right? Is that what you're saying?
Exactly.
Okay.
I think Your Honor has a good understanding of our positions.
Mr. Grunander, anything else?
I would just say bias, credibility, reliability, all of that can be very adequately explored in cross-examination. I think under the circumstances of this case, given really the consistency over time of her statements, but for the one that Alexis talked about where she acknowledged today she thinks she was mistaken, it's been consistent, or there's been more that has come out because of additional questioning. But that doesn't prove taint. The questions were never asked before. I think the remedy, Your Honor, is clearly cross-examination, and I think it would be extraordinary on the part of the court to exclude Ada from being able to testify here.
Your motion, any last say?
I'll refrain.
Okay. Counsel, this is a very difficult legal question. It's an issue of first impression in Utah, at least as it relates to the constitutional question. I'm not aware of any Utah case that has dealt with this yet, and so the citation to other states, to sister states, I think is appropriate, and I will look at those. My intent is to render a decision tomorrow morning at 8:30. Obviously, you can reach stipulations between now and then if you can work something out that would satisfy the defense's concerns and the state's interests. You know, you're always free to do that. Just let me know if you're able to work something out. It's a difficult day. Thank you for your work and your careful attention. Court's in recess.
Your Honor, not to prolong a difficult day, but has the court decided about Roma Henry?
About Roma Henry.
She is the witness notice.
Antimony, Utah.
Yes. Thank you for that. I knew that not to prolong a difficult day would be followed by but. I knew that that's what would happen, so. Yes, thank you. I do need to make a record of that. The issue was the inadvertent non-disclosure of Roma Henry on the state's witness list. She was not listed in the jury questionnaire either. As I considered the arguments, my decision was to inquire of the jury as to whether or not anyone knew Roma Henry. No juror responded that they had any relationship with that individual. Given that, it turns to the issue of prejudice. I'm not persuaded that the defense has been unfairly prejudiced. The defense has known about the substance of Roma Henry's testimony for a significant period of time. I ordered that the state not call Ms. Henry until next week, giving the defense ample time in which to follow up on any issues and to prepare for cross-examination. given the absence of prejudice, I will allow Ms. Henry to testify. Anything further on that issue?
Your Honor, maybe we approach on another issue?
Yeah.